This morning, the Supreme Court handed down a major decision rooted in First Amendment rights, but opponents say it violates the Civil Rights Act. 6 justices ruled that certain businesses can refuse to serve gay people. In this case, they sided with a Christian website designer in Colorado who doesn't want to create websites for same-sex weddings due to religious objections. Kelly Robinson is with us now. She is the president of the Human Rights Campaign. Kelly, thank you for being with us today. This argument that won over the majority was that this is not discrimination because they are not refusing to provide a product, rather they are refusing to provide speech. What do you say to that?
This is absolutely discrimination. It is giving license to businesses to deny services to LGBTQ plus people simply for being who we are, simply for loving who we love. Now, I also think it's true that what this decision doesn't do is provide unfettered access for federal and state governments to discriminate. It should be viewed as a very narrow decision that only applies to original custom goods and services. So, I mean that, yes, it does mean that a website designer can refuse to create a custom website for a gay couple, but they cannot refuse to offer a standard design or template website to that same couple. It does mean that a photographer could refuse to give a custom engagement session to an interfaith couple, but it does not mean that that same photographer can allow that interfaith couple to not have access to a standard package. So we should view this as narrowly, but bigger than that, we should take it as an indication of what the court is doing, and that is rolling back rights and providing the door opening for discrimination in this country to advance.
Earlier this month, HRC declared a national state of emergency for members of the LGBTQ plus community. Would this ruling be as worrisome to you as problematic if it were not in the midst of what we are seeing as a nationwide sort of repudiation of gay and transgender Americans?
This ruling is dangerous on its own, full stop and period. And in this broader context, we have to see it for what it is, part of a campaign of hate and discrimination by our opposition to target LGBTQ plus people for political points. There are organizations that are behind not only the hundreds of bad bills that we've seen in the states, but also behind these court cases that their sole goal is to promote hate. Organizations like the Alliance Defending Freedom, they are the same organization that supported criminalizing same-sex marriage. They're the same organization that was behind the Dobbs case that overturned Roe v. Wade. Let's see this for what it is, a campaign of hate that has to be stopped.
In his ruling, Justice Gorsuch, in his opinion, he raises hypotheticals of, say, a Muslim movie director having to make a film with a Zionist message, a gay male website designer having to make a site for an organization that is opposed to same-sex marriage. And he says without this protection, they could be compelled to do those things. Do you think he is correct there?
I want to talk about the real-life application of what is happening. LGBTQ plus people across this country are already experiencing record numbers of hate crimes against us, an incredible wave of anti-LGBTQ plus legislation meant to harm us, and discrimination that's legalized in more than half the states. I mean, today, a same-sex couple could be kicked out of a restaurant just for being gay. A same-sex couple could be kicked out of a grocery store for holding hands. A trans person could be kicked out of a barber shop. Discrimination is happening in this country now, and it is a real problem. I don't care what sort of rhetoric you try to wrap it in. At the end of the day, this case is legalizing discrimination that has to be addressed.
Thank you so much for being with us. We really, really do appreciate your time. Kelly Robinson with the Human Rights Campaign. Boris?
Let's get the other side of this argument now. We're joined by the attorney for the web designer at the center of the case, Kristen Wagner. She's also the president of Alliance Defending Freedom. Kristen, thank you so much for being with us today. You argue that disagreement isn't discrimination, but isn't refusing a service to someone based on who they choose to marry discrimination?
Well, that's not what's happening here. And I think that there is a lot of rhetoric that's going on about this case. And I would encourage all Americans to actually read the decision rather than rely on the rhetoric. We know that this case involves someone who creates speech. It's stipulated by Colorado that she serves everyone, that she has LGBT clients, but that there are some messages that she will not create. And yes, some of those messages have to do with same-sex marriage, but there are lots of other messages that she won't create that have nothing to do with sexuality. And this ruling protects the LGBT website designer just as much as it protects someone like Lori.
So you're arguing essentially that this isn't about gay marriage specifically?
It's not about gay marriage specifically. It's about whether the government can force an American to say something that they don't believe.
So what are the other issues that she refuses to design websites about, or the other messages that she refuses to endorse on her website?
Well, think of all the different websites that a website designer would be asked to create. Websites that might denigrate people, websites that would express different political views that she disagrees with, websites that would promote atheism or some other particular viewpoint that contradicts her faith.
So what about the argument that there was no actual harm? The question of standing in this case, because this was a hypothetical that was brought before the Supreme Court. Was she actually harmed? She never actually was asked to make a website for a gay couple, was she?
I'm surprised that you're even asking that, in the sense that she was harmed. Colorado has been the most aggressive state.
But she hadn't actually started the business.
She had started the business, and she wanted to go in to design custom same-sex or custom wedding websites.
What I mean is that she wasn't penalized by the state for this. She hadn't actually experienced harm yet.
She had. Her speech was chilled. She couldn't enter into the business because Colorado had consistently, not just against her, but like-minded individuals, said that they would punish, excessively punish, those who would express this view and decline to express a view that supports same-sex marriage. Colorado's notorious. Surely you've heard of Masterpiece Cake Shop.
I actually worked in Colorado when that was happening and spoke to some of the key players in that decision. You were part of that case as well. So it leads me to wonder, is there a campaign on behalf of folks within your organization to target the rights of LGBTQ people?
There's a campaign on behalf of Alliance Defending Freedom to protect free speech for everyone. The court's decision today said that public accommodation laws will continue to apply, that they've coexisted with the First Amendment for decades, and people won't be denied access to goods and services. And we will protect the rights of free speech, including those who support same-sex marriage.
I'm curious about a perspective that was brought about in the dissent from Justice Sonia Sotomayor. Your client believes that marriage should remain between a man and a woman. There are creators out there who believe that marriage should remain between people of the same race. Would you argue on behalf of folks who do not believe in interracial marriage because it is their point of view of the world?
I would not argue on their behalf, and that's a reprehensible view. I think what's important here to remember, though, is that's not the facts of the case the court decided today. The court said that if it's clear that a speaker is distinguishing on the basis of the message they're being asked to create, that they can't be compelled by the government to express a message, and the government can't ruin them because they dislike the message. There are these laws right now. In some states, they actually impose jail time if you decline to express a message that violates your conscience.
So what would you say to folks who feel marginalized by this decision, who say that the message that is being put forward by folks who oppose the right of same-sex couples to marry is reprehensible?
I would say that they have the right, thanks to this decision, to enter the public square and give voice to that view, and to persuade their neighbor, to test ideas, to explore truth, to advance social progress. And all of that is because if we want to have that right for ourselves, we have to protect it for those who disagree with us. That's how we have social progress.
So you mentioned that this is part of a campaign to protect freedom of speech, and obviously you tried a case previously before the Supreme Court in the Masterpiece Bakery case. What is next? What do you have your sights on next?
Well, we're an organization that protects free speech for everyone and religious freedom for everyone. We're going to ensure that this decision applies in the other cases where truly artists, photographers are facing jail time, but also, again, standing for the rights of people of all faiths and no faith at all, that we can all enter the public square and protect the rights of our neighbors and ourselves to be able to engage in robust debate, just like we're doing today.
Kristen Waggoner, I have like a dozen more questions for you. Unfortunately, we have to leave it there. We do appreciate your time and sharing your perspective with us.
Thank you.